today's case is also about this triangular relationship between the branches of government. We're throwing the treaty into the mix. The question that we have is what happens when Parliament integrates part of it into statutory law. Now, the issue arose in what is popularly termed the Sealord case, also known as the Maori fisheries case. In the 80s, what the government did as a way to arrest the depletion of the fisheries was to develop and to implement the QMS, the Quota Management System. What it does is that it regulates commercial catches of fish in New Zealand's territorial waters. Now, how? What we do essentially is we quantify fish and then we allocate proprietary rights over those fish based on a defined formula. A number of Maori opposed the QMS. Maori opposed the QMS because of existing rights. Based on what? Treaty. Precisely, the treaty. Maori also opposed the QMS because the QMS was introduced without regard to the treaty. Third reason they opposed it, many Maori small-scale fishers were excluded from the QMS. Final reason, quotas were perceived as culturally offensive. Why were they perceived as culturally offensive?
Because you have a body outside of the Maori custom telling them what they can and can't do.
Precisely, and we have to think of that in relation to the history here. Once again, put it in historical context. So now you have this external, this foreign body telling Maori how they can go about fishing, when in fact Maori have been fishing for hundreds of years, and the problem arose not with Maori, but with descendants of British settlers. So saying, we managed things just fine prior to your arrival. Culturally offensive. These rights that they were claiming have a number of sources. Now, the first one is Maori cosmology. As we say, based on the protocol, there's a duty to respect Maori custom. And part of Maori custom is this Maori cosmology that says that Tangaroa, the god of the sea, manages fishing. What we also have is the Maori version of the treaty. Maori version of the treaty states very clearly that Hapu will retain Tino Rangatiratanga, or independent control, over all resources, including the fisheries. Now, these rights are also anchored in the English version of the treaty. We look at the English version of the treaty, and it says, Maori retain undisturbed possession of resources, including the fisheries. Next, what Maori point to is the common law. We have the Simon's case, we have the doctrine of aboriginal title, it recognizing Maori, indigenous peoples' pre-existing rights to resources. The final one, we have statutory law. And what Maori pointed to was Section 88, Paragraph 2 of the Fisheries Act, that provides explicitly that nothing in this act shall be deemed to affect Maori fishing rights. What is known as the Maori Fisheries Act, 1989. And what this act provided was for the transfer of 10% of the quota to an inaugural Maori Fisheries Commission. However, that did not resolve the issue. A series of other cases, subsequent cases, were brought before the courts. We're in the post-1975 period. And we know in the post-1975 period, the courts were more willing to give voice to some of the promises that had been conveyed via the treaty. So in one of the cases, the Court of Appeals issued an order preventing the Ministry of Fisheries from taking any further steps towards implementing the QMS until this matter is resolved. opportunity for a negotiated settlement, a negotiated way out of this conundrum, arose with the sale of Sealords. Now the deal would allow the Maori Fisheries Commission to purchase half of Sealords. By purchasing half of Sealord, what they were acquiring was 13% of the quota. Now add this 13% to the 10% that Maori already possessed. That gives you 23% of the quota. So this is the settlement. When we say that we have a settlement, what are we saying about the parties and the dispute? Pleasant. We have disputing parties, adversaries, and they've reached a settlement. They've reached a settlement. So the dispute is being laid to rest. However, as was pointed out, many Maori were left out of the negotiations. Since they were left out, we had several iwi who opposed the settlement. Maori were opposing the QMS because it was in breach of all of these rights, because it had excluded a number of small-scale Maori fishers, because it was culturally offensive. And then now we've reached an agreement that preserves the QMS. So this negotiated settlement undermines the original claim. Second challenge, this undermined Maori autonomy. How? The government was appointing members who headed these commissions. The government was appointing these commissioners. That is inconsistent with Maori autonomy, that is inconsistent with Maori self-determination. Third one, an obvious one, lack of representation. The negotiators did not represent all Maori. They represented some Maori. Lastly, there was a complete absence of public deliberation. These negotiations were held in secret. What this opposition amounted to was a challenge in the courts against the Sealord deal. Who is bound by this deal? Maori negotiators, so we're clear, said that they were only negotiating on behalf of the iwi who had empowered them to do so. The Crown didn't even suggest that this deal applied to Maori who weren't party to negotiation. However, we had the enactment of the Fisheries Settlement Act. And what Parliament did in that act was confirm that the deal extended to all Maori. So the question as to who is bound by the settlement is inconsequential, because the Crown was explicit in its willingness or its desire to extinguish pre-existing Maori fishing rights. Because of this act, the courts never in fact decided whether or not Maori ever had any pre-existing rights. No other case would ever be heard on this issue. All claims, however sourced, current and future. What we need to be clear about is that this case reaffirmed parliamentary supremacy. So the judiciary didn't have a chance to resolve this dispute concerning pre-existing rights because we have a statute that was made by Parliament that extinguished those rights. Parliamentary supremacy provides Parliament with the authority to extinguish treaty rights, even if Parliament has previously legislated for the protection of those rights. Parliament is supreme. Parliament makes the laws. Courts, the judiciary, courts will interpret those laws. And some justices have argued that there are some rights that are so important to the makeup of New Zealand society that even Parliament cannot breach them. Does this mean that courts will overrule parliamentary decisions? No, it does not. What is plausible is that the courts are going to apply the law as Parliament had intended. In a situation where there's an egregious violation of someone's human rights, even if it happens to be sanctioned by Parliament, it is plausible that some justices will stand up to Parliament, regardless of parliamentary supremacy, and say, no, no, that does not fly. The bottom line is that Parliament passes the laws it pleases. And there is no one in New Zealand, including the courts, that can prevent it from doing so. And Parliament can do as it pleases with regards to the treaty, because the treaty is not part of New Zealand's legal framework. The treaty principles are. And even if the treaty were part of New Zealand's legal framework, so long as it stands as an ordinary law, Parliament can still do as it pleases.